Hello, everyone, and welcome to this Federalist Society virtual event. My name is Marco J. Lloyd, and I'm Assistant Director of Practice Groups for the Federalist Society. Today, we're excited to host a webinar, Is Efficiency Desirable in Civil Rights Enforcement? This is the third installment in our Theories of Presidential Power series of webinars, previewing the upcoming 13th Annual Executive Branch Review Conference, which will be held on May 7th at the Mayflower Hotel in Washington, D.C. We are very excited to host an expert panel today. In the interest of time, I will only give very brief introductions, but their full bios can be viewed on our website, fedsoc.org. Dr. Lindsay Burke is the Director for the Center for Education Policy and Mark A. Colocatrones Fellow in Education at the Heritage Foundation. Professor Gail Harriet is a Professor of Law at the University of San Diego School of Law. Catherine Lehman is former Assistant Secretary for Civil Rights in the U.S. Department of Education, as well as a former chair for the U.S. Commission on Civil Rights. Professor Shep Melnick is a Thomas P. O'Neill Jr. Professor of American Politics at Boston College and co-chair of the Harvard Program on Constitutional Government. Our moderator today is William Trackman. Will is General Counsel at Mountain States Legal Foundation and former Deputy Assistant Secretary for Civil Rights in the U.S. Department of Education. If you have a question at any point in today's program, please enter into the Q&A function at the bottom of your Zoom window. We will do our best to answer as many as we can. Finally, I'll note that, as always, the Federalist Society takes no position on particular legal or public policy issues, and all expressions of opinion are those of the speakers. With that, Will, thank you for joining us today, and the floor is yours.
Thanks, Marco. Well, it's an honor to even have a seat at the table today among our August guests. A few housekeeping items. As Marco mentioned, there is a Q&A box on your screen. We're going to go for about 45 minutes to an hour today. We'll stop at an hour sharp if we go that long. And the earlier you get your question in, the more likely it gets answered. And there is an anonymous button or anonymous option if you choose that. And with that, I am going to just jump into it in the interest of time and start by turning it over to Professor Gail Harriet for her commentary.
Well, thank you then. Okay, the first thing I want to say is that I believe that waste and fraud are bad things. I therefore support President Trump's efforts to eliminate fraud and waste. And I'm pretty glad that he's trying to make good on President Reagan's promise to get rid of the Department of Education. Education as such should never have become a federal focus. Let's dismantle the unnecessary parts and put the necessary parts elsewhere in the federal bureaucracy. Still, I get really worried when people focus too much on speed and efficiency and when they're talking about putting all civil rights functions into one or two big efficient agencies. Don't get carried away here. The framers of the Constitution wanted separation of powers, not because it's speedy and efficient, but because it's not. They didn't want power to be concentrated all in one place. Even within Congress, they wanted it to be bicameral because it slows things down. They wanted deliberation. These days, we need to worry about concentrations of power and expertise, even within the executive bureaucracy. While all executive power is assigned to one president under the Constitution, as a practical matter, there are pockets of power that the president will never be able to have effective control over. We should want to avoid unaccountable concentrations of power. I'm not surprised that many voters are impatient. The restructuring that we seem to be undergoing is long overdue, but I want that restructuring to be a success. Let me give you one example from history where acting too quickly in the name of speed and efficiency in civil rights enforcement made things worse. As the Trump administration goes about restructuring the executive branch, it's going to need to keep a sharp eye out for such things. So back in 1964, when Title VII was passed, Congress created the EEOC. They went out of their way to not give it a lot of power. They rightly feared that it would become one-sided ideologically. They didn't want to give it the power to adjudicate alleged Title VII violations or the power to issue substantive rules that would govern be binding on employers and employees, and they didn't want to give it the power to sue employers. The only power it had was to mediate disputes between employers and employees or job applicants. Its job was essentially to prevent Title VII cases from clogging up the courts by resolving as many as possible of them informally. Meanwhile, the power to bring lawsuits against employers, that was vested in the Civil Rights Division of the Department of Justice, which was thought to be more accountable to the president. That worked tolerably well until the Nixon administration decided it would be more efficient and speedy for the EEOC to be assigned the litigation authority over private employers. That turned out to be a bad idea. Congress turned out to be right that the EEOC was going to be one-sided ideologically. Soon it began pushing a legal theory that it knew was not what Congress intended, that is, disparate impact liability. In essence, the EEOC interpreted Title VII to require not just equal treatment, but actually equal results, unless the employer could show that it was driven by actual business necessity that caused it to insist on particular job qualifications. And the Supreme Court, to its everlasting discredit under the leadership of Nixon appointee Warren Burger, let the EEOC get away with that theory in the very well-known case Griggs versus Duke Power Company. And here's the problem. As far as I've been able to tell, all job qualifications have a disparate impact on some group. It's not always the same group, but there are a lot of national origins, a lot of religions, races out there, two sexes, at least so I'm told. On average, men are stronger than women. Women tend to be better at fine handiwork than men. Chinese Americans tend to do better on most measures of mathematical ability. Hispanic men are more likely to have the strength and size qualifications to be championship jockeys. Vietnamese Americans are more likely to have experience in the manicure industry. I could go on forever on that. My point is basically that disparate impact liability, under it, everything that an employer could want in an employee is going to be presumptively illegal, and that gives the EEOC very broad discretion. They can't sue everybody, so they pick and choose which disparate impacts they don't like. All they have to do is issue one of their famous guidances, and they have, for example, in the case of criminal records. The EEOC thus became more powerful than it would have been if Congress had had given them notice and comment rulemaking authority. And it's done by guidances. It can be done in a much more streamlined way, and it's much more difficult for an employer to bring an immediate action against such a thing. So back before the reassignment, the authority to bring the actual lawsuits was with the Civil Rights Division. And so employers didn't so much need to panic once a guidance was sent out. Only DOJ could sue. And back in those days, at least, the Civil Rights Division was not crazy. Indeed, I have it on very good authority that back in the 1970s, the attorneys at the Civil Rights Division would just laugh their head off at some of the EEOC antics. And there was no way they were going to automatically follow up with the EEOC's guidances. The reassignment actually helped create that concentration of power. The EEOC essentially had broad legislative power.
Gail, we lost you there for a second. So I think we're going to move to Professor Melnick.
They, of course, had the...
Gail?
I'm back.
She's back.
Yes. Okay, great. Just another minute or two if you are okay with wrapping up.
What I was trying to say here was that the EEOC therefore had a concentration of power they wouldn't otherwise have, because that reassignment from the Civil Rights Division, and the Civil Rights Division would not necessarily have followed what the EEOC had done back in the old days. And it had that concentration of power. So while it's not my claim that things were in perfect balance before that speed and efficiency reassignment, it was better. It was better than it is now. So I hope that the lesson that I'm talking about here is clear. We need to think about more than just speed and efficiency as we undergo efforts to cut waste and increase efficiency. We need to be on the lookout for hidden concentrations and sometimes not so hidden concentrations of power, even within the executive branch. So I will stop there, except to say that we hear a lot, we have over the last few decades, about like czars within the executive branch, border czars, drug czars. I don't want a civil rights czar. I don't want a single agency or even a couple of agencies. I think spreading that power out is better. So I'm sure I've used up my 7 minutes there. So.
Yeah, I mean, even Russia got rid of czars, right? So, well, Professor Melick, I would love to hear your take. And it sounds like part of Professor Harriet's analysis involves, the devil when you go too fast, you're likely to make mistakes and upset the status quo. So I'd be curious to get your take on speed and efficiency broadly, and then also the propensity to make errors if you're seeking out something and maybe not considering all the consequences.
Sure. Well, first, thank you for including me in this really diverse panel. I think that's a real strength of the Federalist Society, that they present competing points of view. So I'm going to make 3 quick points. The first point is that the way we measure efficiency for the Office of Civil Rights is both artificial and accidental. It came out of a famous lower court decision, Adams versus Richardson, that started in the 1970s. To be more specific, Appendix F issued in 1974. And the court there said that in order to get the Nixon and Ford administrations to move more aggressively on civil rights matters, that OCR, then the Department of Health, Education, Welfare, had to investigate every complaint it heard, and it had to do so within a certain time frame. That was really a product of the Nixon administration versus civil rights organizations battles. But before long, it became the cornerstone of how the Office for Civil Rights measured its efficiency. It's interesting that both the Ford administrations and the Carter administration heads of OCR really rebelled against that. They said we should have more resources for compliance reviews rather than for complaint investigations, because we shouldn't be tied so much to what happens to come in the door. But they lost. And I think there are a couple of reasons why that measure of efficiency, which is how many complaints have you completed in a timely manner, became the standard. For Democrats, this is true in the Carter administration, and I think later on, basically there's a way of saying, we have so many complaints, we need more money, we need more staff. And that was sometimes a compelling argument. For Republicans, especially during the Reagan and Bush administrations, it was to say, see, we're doing better than the Democrats because we're closing these cases more quickly than the Democrats. Perhaps because they didn't investigate them so fully, but it was very convenient for Republicans and Democrats. And as my teacher, James Q. Wilson, emphasized, a bureaucracy needs to have something it can show it's doing, and it's doing well. And this was the way in which OCR could say, look, we're doing all these things. And in their annual reports, they'll say, look at these cases that we resolved quickly. But this is my second point, which is that I think this system is becoming unsustainable. One reason for that is because the number of complaints has escalated dramatically, especially over the last 5 or 6 years. Secondly, the number of staff in OCR, always relatively small. I think under Catherine Lehman, it was about 550. Now it's been cut to 250. So increasing tasks, decreasing staff, you can't do it. Another reason why it's both not only unsustainable, but a real misallocation of resources is because a surprising number of these cases have been filed by individuals who are filing thousands of complaints, which means it gives them really the authority to determine how OCR is going to use its resources. And I think that no matter what your view of civil rights enforcement is, that's not a good way to proceed. We ought to have more flexibility to have the people appointed to the agency be able to decide where the resources should go. I also have a complaint about the way in which complaints were handled for decades in OCR, which was that the argument was that these were cases that had to stand and fall on their individual merit. And OCR in all of the letters saying, this can't be a precedent for anything else that happens. So we were in, I think, a relatively non-transparent way, not building up a common law using these complaints, but really kind of having a highly non-transparent decision-making process. And I will give some credit to both the Obama and the Biden administrations for publicizing more of these compliance letters. But I think we need to have a different way of allocating resources within the agency. So that's my second one. Third point here is that several of us on this panel were quite critical of the Obama and Biden administration's use of Title VI and Title IX. We criticized the way in which they greatly expanded their interpretation of these statutes. We criticized them for using dear colleague letters rather than regulations, notice and comment regulations. We criticized them for using investigations as a form of punishment rather than real investigations. But what are we seeing right now? We are seeing all of these flaws being magnified by the Trump administration. And I really think the people in the Federalist Society should say, you know, this is not what we want from the Department of Education. This is not what we want from the federal government generally. So whether or not the current education OCR stays in Department of Education or whether it goes to Department of Justice, I'm not sure it's going to make a big difference. I think the big question is, are we going to correct some of these overextensions of federal administrative power? Are we going to try to make the process more law-like? So far in the Trump administration, I've seen just the opposite, and I hope at some point we reverse that. Thank you.
Thank you, Professor. I suppose someone might say it's sort of like the tariff conversation, which is the way to backtrack on all of the negative things that OCR does is by doing them a lot, so that everyone agrees that they should never be done again.
Yeah, this is something that can unite Democrats and Republicans, I think.
Well, with that, I want to turn it over to the Honorable Catherine Lehman for her take on efficiency, and then any commentary on either Gail or Shep's remarks so far.
Great. Thank you so much. Thanks for having me. And also thanks all of us and all of us watching and participating for attending to this issue that I think is so important. I'll dive right in and agree with all of us, I think so far, that yes, efficiency is a desirable outcome in federal civil rights enforcement. And I'll just offer a couple of examples for why, and then turn to the rest of our questions. But the first and the core principle is that no student, no school community has a minute to waste. Their civil rights protections are core obligations, core commitments that every student should enjoy as a part of a learning experience every day that the student is learning. And here's some examples from some recent OCR enforcement cases that I think highlight why efficiency matters. One is a case in which the office wasn't particularly efficient. In 2016, the office had received a complaint about whether students with disabilities in the Rapid City School District in South Dakota were receiving their rights as guaranteed under Section 504 of the Rehabilitation Act. And it took 5 years for OCR to resolve that case, to my enormous regret. I have lots of thoughts about why it didn't get resolved in the prior Trump administration. But the ultimate investigation and resolution reflected that the district had imposed an arbitrary cap on the number of students with disabilities it would serve. And those students who exceeded that cap just didn't get served. And that's, of course, unlawful. And of course, students with disabilities who had to wait 5 years for relief will never be fully remedied from the cumulative harm of unequal education over all that time. So, I deeply regret the inefficiency. I deeply regret the time that students in any of our schools didn't receive the equal opportunity to education that Congress has guaranteed for them every day. Just another couple of examples. In last December, OCR secured a resolution agreement addressing retaliation against Jewish parents who had advocated for non-discrimination for their students after OCR identified concerns that the school district had produced no evidence that it even assessed whether a teacher's social media post naming the parents who had complained about staff harassment of Jewish students was retaliatory, and the district had taken no steps to address that retaliation. So, that's incredibly dangerous for parents to be doxxed on social media because they spoke up to protect their students, and incredibly dangerous to the opportunity for equal education in schools. Finally, just a really concrete example, OCR had several resolution agreements related to pregnant students in the Biden-Harris administration. And just, really one concrete, there's a student whose pregnancy made her too large to fit in the desk that the university had offered to her. And she complained and she asked for a different desk someplace so that she didn't have to stand during class, and she never received any relief. That, the duration of a pregnancy is typically 9 months, and there's not a lot of time to wait to accommodate a student's need to be able to realize her dreams and equally participate in school. So yes, is the short version. Efficiency is a desirable outcome. Just so it doesn't go without saying, effectiveness also is a desirable outcome, and it is OCR's job to enforce federal civil rights laws in federally funded schools every day for every student whose rights have been violated. So I appreciated the reference from Professor Melnick to the Adams litigation that spanned 20 years and was focused on ensuring efficient resolutions for OCR. And obviously, or maybe not obviously, it was obvious to me that OCR has over time, including in response to that litigation, identified various ways to maximize efficiency. And I'll just name a few from recent examples. We, in the Obama administration, we added an endpoint for negotiations. Until we had put that into the complaint processing manual, there were several, I will not name them, but several school communities that had been putatively in negotiations with the Office for Civil Rights for 5 or more years. Having been told that their practices violated the law, they were not actually negotiating in good faith, and OCR didn't have an effective means to end those conversations and to get to the place where the school either had to put up or shut up, meaning that the school had to come into compliance as OCR saw it or put OCR to its proof. And so I thought that was an important efficiency to have in place, and I'm glad that it has stayed in the time since. OCR has obviously also trained staff, supported staff to be able to know all the laws in their jurisdiction and to be able to effectively and efficiently enforce cases. OCR has added, as Professor Melnick mentioned, transparency about the issues in investigation and resolutions. I think that is important for sharing with school communities what OCR's expectations are, and also sharing the ways that OCR applies the law to particular facts. In the summer of 2022, OCR updated the complaint processing manual to create a new process for mediation if a complainant requests it. And in the first fiscal year that followed that addition, OCR saw a 400% increase in successful mediations compared to prior practice. So that was an incredibly important efficiency that OCR added. Also, just to say it, notwithstanding the highest caseload in history during the Biden-Harris administration, OCR resolved the second, third, and fourth highest number of cases ever during each of the full fiscal years of the Biden presidency. Putting some concrete stat, OCR resolved nearly 8,000 more cases during the Biden presidency than during the prior Trump presidency, and fully 80% of the total number of cases resolved in all of the Obama presidency's 8 years. So fundamentally, the efficiency concern for OCR is an issue of people. And also Professor Melnick adverted to the decrease in staff and the increase in complaints. Just to really make that concrete, OCR's complaint volume roughly tripled from 2009 to 2025. And in that same time frame, OCR staffing reduced by about 60 investigators. And Professor Melnick mentioned, now that the Trump administration has closed more than half of OCR's enforcement offices and lost roughly half of the enforcement staff, OCR will be seriously hampered in its ability to perform its role. Just to say it though, as we're talking about efficiency and as the advertisement for this webinar mentioned, there's some conversation about whether to move OCR over to the Department of Justice. And so doing would necessarily involve a loss in efficiency in addition to the lack of need for doing it. But let me just say why that's, I think, a fundamental mistake. The Department of Justice litigates. The Office for Civil Rights at the Department of Education engages in administrative enforcement. Those are very different activities. The litigation question involves thinking about which cases present the best facts, in which jurisdiction the law needs to be moved or cemented or secured. And so, whether there's an open question in the Third Circuit that is not open in the Sixth Circuit is the kind of thing that litigators are thinking about. And the Department of Justice over time has been picking and choosing its cases to decide, are these the facts that will best show a judge the importance of a particular issue, that best frame a particular issue, et cetera. The job in the Office for Civil Rights, the regulatory charge, is to investigate whenever the office has information that the law may have been violated. So it does not pick and choose its cases. It answers the question for anyone who comes to the office about whether their rights have been violated. And that's a beautiful opportunity for anyone, anywhere, to be able to ask for information from civil rights experts and to get an answer. And that is not forthcoming from the Department of Justice by design, but it is persistently forthcoming from the Office for Civil Rights. And if the office were moved to the Department of Justice, then the Department of Justice would have to develop that new muscle and fundamentally change the way that it's doing work. That would be inefficient. That would mean that students' rights would be waiting, and our kids don't have that time. So it is, I think, profoundly a mistake. It is also well outside the existing capacity of the Department of Justice. The Education Opportunities Section and the Civil Rights Division at the Department of Justice has fewer than 20 people, or had fewer than 20 people when the Trump administration began, and it has fewer still than that now. The Office for Civil Rights, when I last left it, had just over 600 people at the end of January. Obviously, it's lost quite a few people since then, but in the hundreds that it still has, it well exceeds the staffing at the Department of Justice. Just figuring out how to mechanize incorporating that work that is so different, the staff and the staffing that involves very different questions, will take time away from fourth graders today getting an answer about whether their rights have been violated. So I think that it is a mistake. It is dangerous to move the office, and it's also bad for kids. The other topic that we said we would talk about today is whether we need different or better checks and balances for federal civil rights enforcement in the government. And I think it's important just to make sure that all of us in the webinar know what checks and balances exist today. So there's an executive order issued in the Carter administration in 1980 that gives the Department of Justice civil rights coordinating authority for Title VI, Section 504, Title IX, for any law that prohibits discrimination based on protected characteristics. And DOJ has historically been pretty adept at doing that coordination. They also regulated to incorporate that executive order into their regulatory charge. So DOJ says, it's in their Title VI legal manual, if two federal agencies issue conflicting policy guidance on a regulation or a topic of civil rights, DOJ is authorized to determine what the final government-wide position is. That's its coordinating authority. It's also required to issue model Title VI, other civil rights regulations, and to provide guidance to all of the agencies. And my experience is that DOJ has been a very willing partner in coordinating, approving every policy guidance that any of the civil rights agencies issue and every regulation draft and final before their issuance, and working hand in glove on legal interpretation. So that existing check in the federal government with DOJ as its own entity, but coordinating each of the federal civil rights enforcement agencies across the government has been pretty effective. I have my own worries about its operation in the current moment, but it is an existing check that I think is important for all of us to be thinking about. So I'll stop there. I will look forward to questions and appreciate this conversation so far.
Well, thank you for the remarks and for the insight into your term as Assistant Secretary in the Biden administration. With that, Lindsay, I want to turn the floor over to you to present your remarks and then also address anything from the other remarks that you wanted to talk about.
Great. Well, thank you, Will, and thanks to everybody. This has been a great discussion so far, very informative. The federal government has been accused of many things over the years, but efficiency certainly isn't one of them. And that clearly applies to the U.S. Department of Education. And I do want to just take a step back and paint a big picture to think about what it has meant for your typical American student to have a federal Department of Ed. And you really have to go back 60 years, talk about lack of efficiency, to the Great Society, to the Lyndon Johnson era, to really understand the point that we're at today. When Lyndon Johnson launched the War on Poverty as part of the Great Society effort in 65, one of the chief goals within the education component of the War on Poverty was to narrow achievement gaps between children from lower income families and their more affluent peers. And I also think it's notable to point out that about a third of the War on Poverty was education related. Johnson says this in his remarks when he launches the War on Poverty in 1964. He says 1/3 of the War on Poverty will be fought in the classrooms of America. And he says, there your children's lives will be shaped. And so from the very beginning, the War on Poverty was an education effort to try to narrow those achievement gaps and improve outcomes for children from lower income families. And so I think the question that we really have to ask ourselves is whether or not federal involvement in education, which predates the creation of the Department of Ed by 2017 years or so, whether that has actually delivered on its promises. If you go back to 65, when Johnson was launching that War on Poverty, the gap between low-income children and their more affluent peers, so it's frequently referred to as the 90-10 gap, kids from the bottom 10% and the top 90%, that difference was the equivalent of 4 grade levels worth of learning, 4 grade levels worth of learning. Today, it is exactly the same, unchanged. The equivalent, that 90-10 gap, is 4 grade levels worth of learning. And so we really haven't seen the needle move in any appreciable way, in the way I think we would all want to see it move, to see those gaps in reading and mathematics narrowed. We're at the point today where, it's still the fact that 70% of kids are not reading proficiently. And so if we think about civil rights sort of in the broader context of illiteracy and innumeracy, we really do have a significant problem that federal intervention has failed to address over the years. So I think the history is illustrative because this was a big part of the argument that Jimmy Carter made for the Department of Ed. When Johnson created all of this federal intervention in education, which, by the way, went all the way from preschool through higher ed, we get the federal Head Start program in 65, we get the Elementary and Secondary Education Act in 65, we get the Higher Education Act in 65. So the first significant major federal involvement in ed all goes back to 65. But the programs were sort of all over the place in various federal agencies, health, education, welfare, et cetera. And so part of Carter's argument was that if you create a cabinet level agency for education, it would create efficiencies. The administration actually said federal programs have failed to solve the problems to which they were addressed, such as rectifying inequalities and educational opportunity. Creating a cabinet level agency will lead to the types of efficiencies that could improve outcomes. And so this was the stated purpose of creating the Department of Ed in 1979. The Department of Education Organization Act was signed in 79. It went into operation 6 months or so later in 1980. What is notable too, though, is that while that was the stated rationale for creating the department, there was really a political purpose, of course, behind it, which was this marriage of political expediency between the Carter campaign when he was running for president and the teachers' unions. Carter had made 2 promises and kept both of them. He said, look, I will tap Walter Mondale as my vice presidential running mate. Walter Mondale's brother was a higher up in the teachers' union at the time. And more importantly, I will create a cabinet level agency for education. So he got the endorsement of the NEA. They were newly powerful. It was their first presidential endorsement. And of course, rode that ultimately to the White House. And so we see the department come into operation in 80, and yet nothing changed from 1980 to today in terms of academic outcomes, narrowing of achievement gaps, improvements for disadvantaged students in terms of their graduation rates, our international standing in the world. And so all we have really gotten as a result is indeed efficiency, but efficiency for one particular group, and that group is special interests like the teachers unions, who have a nice, convenient one-stop shop to be able to lobby the federal government now for policies that are in their best interest, rather than an agency that has done anything to really effectively improve the educational outcomes of American students. So perhaps the answer is efficiency is not desirable if it means that at the end of the day, that empowers our special interest groups to achieve ends that further the goals that they have in place rather than those of students.
Thank you, Dr. Berg. So let me just put this to our crowd. We already have questions rolling in. Again, we're going to go until about 2 p.m. Eastern. So if you have a question, go ahead and drop it in the Q&A box. But before we get to that, I'd love for the panelists to interact a little bit. And it strikes me that each of you have presented different definitions or operationalizing efficiency differently. So it could mean that we're getting rid of bloat if we increase efficiency, or it could mean that we're increasing the number of people and hours that we work on civil rights issues because that will get to results faster, or it could mean something else like cutting programming that doesn't work. So it sounds like a lot of our interaction is about what efficiency means. And I'd be curious if any of our panelists have takes on how efficiency is or what someone else has said about what efficiency means.
I'll just make 2 quick points. One is that you can't know what efficiency means unless you know what goals you're aiming for. And I think that there are some pretty big differences between the views of Republican and Democratic administrations on what that goal is. Should it reflect a colorblind understanding of Title VI and the Equal Protection Clause, or should it basically an affirmative action view? So efficiency in this area that's so polarized is not a particularly good way to think about these things. The other thing I'd say is that there's the big battles over what are the policy outcomes do you want? And the relationship between that and where you put organizational boxes is quite unclear. You know, if we moved everything back and had a new Department of Health, Education, and Welfare, well, we kept OCR the way it is. We kept Title I spending the way it is. We kept special education spending the way it is. I don't think things would change very much. But I will just to second something that Catherine Lehman said. If you took OCR from education and made a separate element within the Department of Justice, I don't think a lot would change. If you tried to integrate it with other things in the Department of Justice, I think her argument that you're really putting together apples and oranges is a very strong argument. So how you do that reorganization and how you define what you're trying to achieve in civil rights law are obviously the 2 really monster questions behind this.
I'll jump in. I certainly agree with all that Professor Melnick was just saying, and I think it's worth considering also the atomizing of efforts that I appreciated Dr. Burke's history of what President Carter had been trying to achieve in terms of the effectiveness of a single agency. I will just offer, in my experience, that teachers' unions and any other advocates are quite capable of doing their advocacy across any of the entities that they might need to. So I don't know that we gain efficiencies or lose them if the issues that the Department of Education addresses are atomized. But I do think that having all of the parts of an entity all focused on what happens in school, it is itself very important. And just to offer some examples, in our enforcement work in the Office for Civil Rights, and just to say, the Office for Civil Rights has independent enforcement authority, and so isn't particularly subject to the vagaries of the advocacy of the various organizations, et cetera. But the work that we do involves identifying and negotiating with school communities what would work to correct a harm once the Office for Civil Rights has identified it. And we tend to be pretty good lawyers. We tend to be pretty good at civil rights knowledge and that information, but not having the backstop of other people in the department who have expertise in how dollars flow in a university, or what the impact would be on students' ability to access federal financial aid, or the mechanics of elementary and secondary education, and what works. The civil rights experts who are negotiating potential resolutions may well try to impose on school communities obligations that are totally unworkable for them, that other people in the department who have expertise in the grant making and in the day-to-day functions of school communities have a lot more knowledge about. And it's been really beneficial to be able to have the back and forth there. If the Office for Civil Rights is in one entity and elementary and secondary education is someplace else, and the banking part of federal student aid is in still another entity, and then the higher education support, substantive support work is still some other place. Very hard to get that expertise and that knowledge and to be informed by it. So I think that the atomization that was a basis for creating the department in the first place is a very real harm to school communities and to student learning that isn't particularly beneficial for us to revert to. And there is a reason that Congress created in 1979 a single locus for all of that work.
Professor Harriet, I took you to say something like increasing efficiency means concentrating power and cutting red tape and making things easier to get out the door, but that sometimes that could be removing protection that actually has an incidental positive effect.
Yes.
Do you care to comment on that and what efficiency means to you?
Your point was correct, that we're all using the word efficiency differently, because that's in the nature of the word efficiency. There's a zillion different ways in which you can sort of measure what efficiency mean. I mean, to some people, what they're talking about right now is, can we save taxpayer money and have exactly the same output? And I take Catherine to be saying in part, you can't cut the staff and expect that they're going to be doing the same amount of work. And what I'm saying here is that sometimes the word efficiency, we're talking about, can we get to policy goals faster, without having to consider quite so much. And what I'm concerned about is overreach. And that's what the framers were concerned about. And is it possible for the executive branch to do too much? Because it's been made in such a way that they can move very quickly and very smoothly without having to consider as much as they would have to consider. I would prefer, you were also talking about, the devil that we have a lot of civil rights agencies all across the federal bureaucracy now. In fact, Catherine and I worked on a report for the U.S. Commission on Civil Rights that was all about, there were many arms of the bureaucracy that are dedicated to civil rights, and each one is different, and each one has its own culture. And I worry about the notion of moving OCR over to the Civil Rights Division, moving some of these others, creating a much smaller number of civil rights offices, but much larger. And becoming, little fiefdoms of their own. And so I'm concerned about that. I think that it happened with the EEOC under the Nixon administration. It changed the character of what the EEOC was doing just enough to, I think, create overreach that I don't think was intended by the Nixon administration. And I don't want to see it happen under the Trump administration. We need to be very, very deliberate and think very carefully about the incentives that are being created every time a decision is made about how to restructure agencies. What I'm finding here is actually I agree with most of what everybody has said, or at least a large part of it. And that's because there are different meanings to efficiency. And I just want to make sure that the meaning I was talking about, and that is making it too easy for a part of the government to take action before it has completely considered that action, is something that is necessary here. I believe that the president is the person who has all the executive authority. That's what the Constitution says. But realistically, I mean, it's a big federal government. And there are going to be power bases all through that government, and you don't want them to be too powerful, because there's no way in the world that the White House is going to be able to completely control everything, even if one thinks that would be a good thing.
Dr. Burke, isn't it easier to achieve policy goals if you do have an overarching federal agency that can set national policy. I mean, just offering a few examples on women in athletics or civil rights enforcement in affirmative action or other race-based policies. Isn't it easier to have a centralized locus of power as opposed to 50 different policies that might be going out throughout the country?
Sure, easier, but is it appropriate? And let me just paint the big picture again, which is if we think about K-12 education in particular, the federal government's a very small stakeholder. And, lest I be critiqued for not pointing out that there is no constitutional authority for the federal government to be involved in education. It's not an enumerated power of the federal government. But I think the financing component of it alone, right, at the federal level, we're talking about 10% on average of all K-12 funding comes from federal taxpayers. And so I would argue that as a general matter, the rules and red tape and regulations that have emanated from Washington, from the Department of Ed, far exceed that 10% stakeholder share that the federal taxpayer invests in K-12 education. So just from a first principles perspective, it's inappropriate both in that it is not an enumerated power of the federal government, and the intervention that we do see really does exceed the financing share that the feds have.
Do you mind if I just jump in on that quickly? One, the Supreme Court hasn't agreed with that, but I appreciate the argument. But two, the federal government funds 26% of education in the state of Mississippi, and there are 6 or 7 states where the federal government counts for more than 20% of the education spending in those states. Those are states like South Dakota, Alaska, and often heavily rural communities. And I don't think we think that rural kids count less or need fewer resources. And if we don't have that federal backstop for them, then they won't have the same education opportunity. So I quite agree that on average, federal spending in schools is 10 or 11% of spending, but there are some really important kids in really important places where the federal spending is substantially more. And I also think it's important to make sure that those kids have the same access to equal opportunity that any other kids have.
And I do appreciate that. And I don't think I have said this yet, but it does bear pointing out that the proposals that are whispered about or floated out there to wind down the Department of Ed, everything I've seen to date largely talks about something Gail referenced earlier, which is moving some of those core, for lack of a better word, functions to other federal agencies. And then the programs that have a demonstrated track record of being ineffective, or I would add to that list, inappropriate for the federal government to run, or maybe are duplicative, it's those programs that are on the chopping block. And some of the programs that either have a historical justification or are appropriate at the federal level, those programs are retained and moved to other agencies. So I just think it bears pointing out that just because I'm saying eliminate the Department of Ed doesn't necessarily mean programs go away. And this is obviously at the end of the day something Congress is going to have to wrestle with, which programs to keep and which do get the axe. But it doesn't mean that a state like Mississippi would have fewer IDA dollars, for instance. If anything, in our world, it means families would have more control over the IDA dollars that are being spent, to use one example.
Yeah, and we obviously don't want I don't mean to sidetrack us in Lindsay and I debating this, but in point out, we haven't seen what the proposals are, so we don't actually know what is or isn't being contemplated and what would or wouldn't happen. But we do know that block grants in the past have redounded to the detriment of rural and low-income kids, and that hasn't worked well. So there's some real devil in the details worries, and we actually don't have the details, but real reason to be, I think, deeply worried about what could happen.
I do want to get to some audience questions since we have a hard stop in about 10 minutes. The first is for Professor Harriet from Bob Gaglione. What are your thoughts on Executive Order 14173, which helpfully is described here, its significant impact on civil rights enforcement of the Department of Labor by withdrawing a prior Executive Order 11246, which involves affirmative action compliance, I believe.
Yeah, I mean, this is one of those issues that Professor Melnick was talking about, where conservatives and progressives just seem to have a different view. Lyndon Johnson issued Executive Order 11246, back during the Johnson administration. Obviously, I think it was 1965, and it has basically grown into a program where federal contractors are required to seek diversity, I guess we could call it, among subcontractors and such. I think it has been a vehicle for causing discrimination. I'm happy that it was withdrawn. Is it more efficient to not have such an office in the sense of saving money? I guess it is, but much more important to me is in the sense of I don't believe that contractors should be pushed into giving preferences. But should they be pushed into forbidding discrimination? You bet. And we definitely need, we need an office that would ensure that laws against discrimination in that respect are enforced, but I think the OFCCP had been out of control for years.
Next
Mind if
question
I
is
jump in on that one
oh,
also?
yeah, of
Sorry.
course. Of course.
When Commissioner Harriet and I were working together on this report that you mentioned about evaluating federal civil rights compliance, I remember, and Professor Harriet, I'd be very interested in your thoughts on this too, but I remember being pretty wowed by the Trump administration head of the OFCCP at the Department of Labor, Craig Lean, and the efficiencies that he put in place there in his management for that office. It was also a very large office. It was among the largest. It was comparable in size to the Office for Civil Rights at the Department of Education, at about 600 people. And their work to ensure non-discrimination among federal contract compliance was, I think, and I think I heard from Professor Harriet that we agree, incredibly important. And he led really amazing, I thought, initiatives to try to ensure non-discrimination among all of those contractees. And so I think, whereas probably Professor Harriet and I have some disagreement about the degree to which that office has been out of compliance over time, I think we probably don't disagree about how effective it was in the prior Trump administration, actually, as among the other federal civil rights agencies, and they were doing such incredibly important work. So I guess I want to make sure at least we say that here and think about
what I can say is the Trump administration, I think, tried very hard to move the emphasis to non-discrimination and not forcing federal contractors into doing this by the numbers. And I appreciated that from the Trump administration. And I know that our questioner, Mr. Gaglione, in fact, worked for the OFCCP.
Is that right?
And like,
well done.
Wow, doing that good work.
Next question is about canceling grants, which we've seen quite a bit of press about. The questioner, who's anonymous, says, what do you think about canceling Harvard and Columbia grants? Is that an example of efficiency? And is that an example of efficiency that you agree with as panelists? So I'll be curious to have any thoughts from any of the four of you.
Well, one thought was that they need to read Title VI before they start canceling contracts. That Title VI, from 1964 has required a procedure that I can't recite off the top of my head, but basically you got to bring Congress in before you start doing this. And I think that a mistake was made. So, quite apart from the substance of whether or not this is something, that there were violations of Title VI, there may well have been. Slow down. Let's comply with the procedures that are required by law. And I think the Trump administration understands that now. I think they made an error in that respect, but that's an error that they can correct. If in fact the violations of Title VI were there, then we can move from there.
I'd actually look, first of all, I would take my hat off to the Trump administration for renewing my loyalty to Harvard that had waned a lot in previous years. I might even renew my $100 a year contribution. But there are the procedural difficulties, huge procedural difficulties that Gail mentioned. But there's also this understanding that anti-Semitism pervades every aspect of the university's actions. There are some things that the Trump administration, I think, was right to emphasize. Having clear rules about where speech becomes harassment, punishing people who do that. But this whole idea that every grant to the med school is somehow linked to anti-Semitism is really perverse. And it really shows exactly the type of overreaching that we've all been talking about here.
Next question.
I
Oh,
was
go ahead.
to
We
hop
all have
in
stuff to say on
quickly.
this.
I was just gonna, my 2 cents, that there's no academic freedom exemption to the civil rights obligations of a university. And if Harvard does in fact believe that its mission and its understanding of academic freedom are inconsistent with the Civil Rights Act, then it should just decline taking federal taxpayer money. And there were a lot of components to that letter that was issued to Harvard. And while Washington should generally not compel private universities to change the operations that don't actually violate the law, I think the administration's really detailed recommendations in that letter reveal the breadth of the racist and anti-Semitic practices that unfortunately are ongoing at Harvard.
Next
Just to
question is for you,
jump in,
Dr. Burke.
I
Oh, sorry.
could not agree more with Professor Harriet that there's a set of procedures to follow, and they need to be followed, and they are statutory and regulatory and of longstanding. I do disagree that there's any evidence that the Trump administration understands that now. I mean, it certainly reported in the New York Times that it made a mistake in sending that letter. Whether or not that is so, that the administration has not rescinded the requests of other universities that it's made that are very similar, or its practice of withholding funds first and asking questions later, which is not the statutory process. So what it's doing is entirely extra legal, very, very damaging. And I have lots of views about the need for Harvard to change practices, but I actually think Harvard acknowledged that in its own response, which is perhaps late in coming, but I'm grateful that it's there. Harvard is also already subject to federal enforcement at the Office for Civil Rights, already subject to oversight from federal courts in litigation related to settlements that it's made on this topic, and it has begun commitments for what it will do differently moving forward that I think are very important for education there. So this is also, a federal administration jumping in for theater as distinct from for actual protection, given the commitments that already exist for that university.
Next question, Dr. Burke, I think we can squeeze this in, is for you, about putting authority with the states for education, given the comments you made about the achievement gap not being closed. Would anything be different if authority just went to the states and money went to the states?
Yeah, look, I think just quickly, I know we're close to time, but the onus is really on the defenders of the Department of Ed right now to make the case to maintain a cabinet level agency. Having that agency, and even prior to that, having large scale federal intervention did not change the course of those academic achievement gaps. It did not help at the state level, at the local level. It didn't help to narrow those gaps over time. And so I think we are long past time to actually restore state and local control of education. I firmly believe that when you enable families, when you situate dollars and decision making as close to the people it will affect as possible, we are going to see improvements in academic outcomes. And look, to get a little bit askew from where the conversation is today, we are seeing school choice in the states go gangbusters, right? And if we really want to see improvements over time, it's going to come through reform efforts at the state level that largely look like what we're seeing state after state do over the past 3 years, which is adopting universal school choice, enabling every single child in every state to select into a learning environment that is the right fit for them, is safe and effective, and aligns with their values. That's where we're going to see improvement. It's not going to come from the federal department. And so, yes, I do have more faith in states and local leaders than I do those sitting in Washington.
Thanks. We'll leave it there. Thank you to all of the questioners who chimed in today. Thank you so much for our esteemed panelists. It's an honor to even be here moderating. And with that, we'll turn it back over to Marco to close us out.
Well, thank you all for that fantastic discussion and the benefit of your time and expertise today. On behalf of the Federalist Society, I'd also like to thank you, our audience, for joining us. We greatly appreciate your participation. For information on more upcoming events, please visit our website or all major social media platforms at FedSoc. On that note, we are adjourned. Thank you again.